Hi, my name is Omar Abu Naib, and today I'm going to be critically analyzing the rescue mechanisms which were introduced by the Companies Act of 2016 and comparing them with the rescue mechanisms which are pretty much non-existent with the Companies Act of 1965. Now, it is important to note that on the 1st of March 2018, the Companies Commission of Malaysia had enforced Division 8, Part 3 of the Companies Act of 2016 as part of the insolvency framework to help companies in financial difficulties to be rehabilitated under the rescue mechanisms. Now, firstly, it is important to dive into the Companies Act of 2016 before talking about the Act of 1965. The new Companies Act of 2016 had introduced the rescue mechanisms. These mechanisms' main purpose was to rescue a company from insolvency, and in addition to allow it to get back up to the position they were before the company itself became insolvent. Now, under the previous Malaysian insolvency laws, the usual outcome in the event of corporate insolvency is receivership or liquidation. However, neither have the rehabilitation of a debtor company as its main objective. Under the existing corporate insolvency framework in Malaysia, a company that is in financial distress can only restructure by a scheme of arrangements under Section 176 of the Companies Act of 1965. The current laws in Malaysia, it is meant to be understood as the laws which were enacted by the Companies Act of 1965. Now, the Companies Act of 2016 had introduced two main rescue mechanisms, namely, firstly, the Corporate Voluntary Arrangement, also known as the CVA, and secondly, Judicial Management, which is also known as JM. In terms of the corporate voluntary arrangement, it is defined as a binding compromise or arrangement with the creditors of a company without the need for such compromise or arrangement to be approved by the court. Now, the CVA, however, has similarities with Section 176 of the Companies Act of 1965, in which the CVA allows the directors of a company to propose a scheme to the creditors. Now, where does the corporate voluntary arrangement apply exactly? It is important to note that although it was created as a means of rescue, that does not necessarily mean that it is applicable to every single type of company. This can be seen in Section 395, paragraphs A, B, C, and D of the Companies Act 2016, which states, this subdivision does not apply to a public company, a company which is a licensed institution, or an operator of a designated payment system regulated under laws enforced by the Central Bank of Malaysia, a company which is subject to the Capital Markets and Services Act 2007, and the company which created a charge over its property or any of its undertakings. There are 5 main stages to corporate voluntary arrangement, which are, firstly, the proposal, secondly, appointed nominee, thirdly, filing documents in court, fourthly, summoning meetings, and finally, implementation of the CVA. In terms of proposal, Section 396, subsection 1 states that the persons who are capable of proposing a corporate voluntary arrangement are, firstly, the directors of a company other than a company which is under a judicial management order or is being wound up may make a proposal to the company and to its creditors for a voluntary arrangement under this subdivision. Meanwhile, Section 396, sub 2 states that the proposal for a voluntary arrangement under this subdivision shall include the appointment of a nominee, either as a trustee or supervisor for the purposes of supervising the implementation of the CVA itself. In addition to that, Section 396 sub 3 states that a proposal for a voluntary arrangement may also be made by a judicial manager if a company is under a judicial management order, or by a liquidator if a company is being wound up, who may also be the nominee for the voluntary arrangement. And finally, Section 396 sub 4 states that in the case where the liquidator is the official receiver, the nominee shall be the insolvency practitioner. In addition to that, Section 397, subsection 2, paragraphs A, B, and C of the Companies Act of 2016 states that, for the purposes of subsection 1, the nominee shall submit to the directors a statement indicating whether or not, in his opinion, the proposed voluntary arrangement has a reasonable prospect of being approved and implemented. The company is likely to have sufficient funds available for the company during the proposed moratorium to enable the company to carry out on its business. And that the meetings of the company and its directors should be summoned to consider the proposed voluntary arrangement. The second stage in terms of a voluntary arrangement is the filing of documents of the CVA in court. Now, before explaining as to the filing of the documents, it is important to understand the definition of a moratorium. A moratorium can be defined as a temporary suspension of an activity until future consideration warrants lifting the suspension, such as if and when the issues that led to the moratorium has been resolved. Moratoriums are often imposed in response to temporary financial hardships. The second stage of implementing a CVA is the filing of documents in the CVA in the court. This can be seen in section 381, subsection 1, paragraphs A, B, C, D, and E, and F, which states that a moratorium in a voluntary arrangement commences automatically from the time of filing of the documents by the company to the court. Now, a document setting out the terms of the proposed voluntary arrangement, a statement of the company's affairs containing the particulars of the company's creditors and of its debts and other liabilities and of its assets, and other information, a statement that a company is eligible for a moratorium, and a statement from the nominee that he has in fact given his consent to act, and a statement from the nominee and a statement disclosing full particulars of a previous proposed voluntary arrangement or an application for a moratorium and the results of the application, if any. Now, following the requirements of section 398 sub 1, after that, the moratorium commences automatically after filing the documents in court. However, it ends if the nominee withdraws consent to the act under Schedule 7. In addition, Schedule 8 states that during the periods for which the moratorium is in force, no petition may be made or presented or the resolution passed to wind up the company, to application for judicial manager, and no judicial management. In addition, there is no right of forfeiture by re-entry into the premises. Now, the third stage of the CVA is the summoning of. The second stage in terms of a voluntary arrangement is the filing of documents of the CVA in court. Now, before explaining as to the filing of the documents, it is important to understand the definition of a moratorium. A moratorium can be defined as a temporary suspension of an activity until future consideration warrants lifting the suspension, such as if and when the issues that led to the moratorium has been resolved. Moratoriums are often imposed in response to temporary financial hardships. The second stage of implementing a CVA is the filing of documents in the CVA in the court. This can be seen in section 381, subsection 1, paragraphs A, B, C, D, and E, and F, which states that a moratorium in a voluntary arrangement commences automatically from the time of filing of the documents by the company to the court. Now, a document setting out the terms of the proposed voluntary arrangement, a statement of the company's affairs containing the particulars of the company's creditors and of its debts and other liabilities and of its assets, and other information, a statement that a company is eligible for a moratorium, and a statement from the nominee that he has in fact given his consent to act, and a statement from the nominee and a statement disclosing full particulars of a previous proposed voluntary arrangement or an application for a moratorium and the results of the application, if any. Now, following the requirements of section 398 sub 1, after that, the moratorium commences automatically after filing the documents in court. However, it ends if the nominee withdraws consent to the act under Schedule 7. In addition, Schedule 8 states that during the periods for which the moratorium is in force, no petition may be made or presented or the resolution passed to wind up the company, to application for judicial manager, and no judicial management. In addition, there is no right of forfeiture by re-entry into the premises. Now, the fourth step in the CVA is simply the summoning of meetings under the CVA. The approval in terms of meetings can be taken only if the creditors had 75% the majority of present and the voting. However, they cannot approve a proposal that would actually alter the rights of a secured creditor in order to enforce their security except with their concurrence. And the final stage of the CVA is simply the implementation of the voluntary agreement. In terms of implementation, the nominee is to appoint the approved voluntary agreement. The nominee may be replaced on application to court on grounds of death or breach of duty. The right to appeal by any creditor or any other person against an act, omission, or decision of a supervisor, the court may confirm or reverse, or give directions to supervise or make such orders as it deems fit. It is important to note that if it has not been implemented fully, the voluntary agreement thus comes to an end. And now we move on to the second rescue mechanism, also known as the judicial management. The judicial management does not apply to licensed institutions or the operator of a designated payment system under laws enforced by the central bank. Similar to the CVA, judicial management has four main stages, which are namely, firstly, the application to court, secondly, the judicial management order, thirdly, judicial manager, and fourthly is the implementation. In terms of the application to court is made by the company or its creditors for a company to be placed under judicial management and for the appointment of a judicial manager. However, the application must be advertised and notice must be provided to the creditors and to any person who has appointed or intended to appoint a receiver. Section 404, paragraphs A and B of the Companies Act 2016 states that an application for an order that a company should be placed under judicial management and for the appointment of a judicial manager may be made to court by the company or its creditors if the company or its creditors consider that the company is or will be unable to pay off its debts, and there is reasonable probability of rehabilitating the company or of preserving all parts of the business as a going concern, or that otherwise the interests of the creditors would be better served by resorting to a winding up. Meaning that it would not occur unless there is a chance of, there are high probabilities of a company being rehabilitated. It is also important to note that the judicial management order will not be made if the company has gone into liquidation or receivership, or if a secured creditor opposes the application. In addition, once an application is filed for a judicial management order and until the application is disposed of, no resolution may be passed to wind up the company. However, there is one exception, which was if it was done with the leave of the court. No steps taken to enforce any charge or security over company property or repossess any goods under a hire purchase agreement, and no proceedings, process, or execution or distress is to be commenced. Now, there are, however, four main effects of a judicial management order, which are, firstly, once a JMO has been established, no resolution or order to wind up the company could happen. Secondly, no receiver or R&M is to be appointed. And finally, except with the leave of the court or consent with the judicial management. Now, a judicial manager also has powers, especially while the JMO is still in force, which are, firstly, he has the power of taking into his custody or under his control all property for which the company is entitled to, and secondly, exercise all powers and duties of the directors to their exclusion, but there's no requirement to call on any meetings of the company, and thirdly, do all such things as may be necessary for management of affairs, business, and property of the company. Fourthly, cannot make payments towards discharging of any debt sanctioned by courts, or payments towards discharging of sum secured by security or payable under retention of the agreement. Fifthly, he may dispose of the property under a floating charge. And sixth, he may dispose of property other than a floating charge, such as leasing, retention of title agreement, or by order of court. Seventhly, an advance notice must be made 7 days prior to the application in order to dispose property subject to a security is made and must be given to a security holder or owner. And finally, the judicial manager is deemed the agent of the company, meaning that he is therefore personally liable for contracts that he had entered and adopted unless it has been expressly disclaimed. And finally, for the last stage in terms of judicial management is the implementation. Once a judicial management order is made, the judicial manager is to advertise and serve notices on all the creditors and on the company. Then the company shall, within 14 days, which is extendable up to 60 days by the judicial manager, submit the statement of his affairs to the JM. The judicial management shall, within 60 days or longer, as the courts may allow, send a proposal for achieving a purpose under Section 405(1)(b) to registrar and all the creditors. Now, Section 405, subsection 1, paragraph B, states that where a company or its directors, under a resolution of its members or the board of directors, or a creditor, including any contingent or prospective creditor or all or any of these parties, together or separately, makes an application under Section 404, the court may make a judicial management order in relation to the company if the court considers that the making of the order would likely to achieve one or more of the following purposes: lay before meeting of the creditors and the proposal, send a copy of the proposal to all the members of the company, and public notice in a newspaper stating where the members may request for a copy. Then the creditors' meeting to approve or reject the proposal occurs. However, approval occurs once 75% of the majority of creditors whose claims have been accepted by the judicial management and who are present and voting is required. Then the judicial management is to report the outcome of the meetings to the court. If the meeting declines the proposal, the court may discharge the judicial management order, make consequential provisions to the JMO, adjourn hearing, or make any other order deemed fit. Sometime later, if the meeting approves the proposal, the committee of creditors may be established in order to oversee the judicial management. Then the judicial manager shall carry out the proposal. The judicial manager also shall apply to discharge the JMO if it appears that the purpose for which the JMO has been achieved cannot be logically achieved. Now, the question is, are these rescue mechanisms effective? If they are, then what difference will it do if we compare it to the Companies Act of 1965? Firstly, when it comes to comparison of the Act of 2016 with 1965, the Companies Act 1965, unlike the 2016 Act, there are limited options to an insolvent company. Such options are receivership, winding up, or entering into a scheme of arrangement with the creditors. However, it is very important to note that the 1965 Act did not have rescue mechanisms per se. That is to say that the available options do not actually rescue a company from winding up, meaning that receivership, winding up, or entering into a scheme of arrangement with the creditors does not mean a company shall be rehabilitated after it has gone through insolvency. Now, the Companies Act of 1965 pretty much offered little to nothing when it came to rehabilitating a company from an insolvency state, or in other words, rescue mechanisms. The only thing closest to a rescue mechanism, which is not exactly a rescue mechanism, would be found in Section 176. However, this section has had issues which do not actually rescue a corporate company from insolvency. In the 1997 financial crisis in Malaysia, companies began frequently using the restraining order provisions in Section 176 in order to secure extended judicial protections from creditor actions. This application was thus abused by companies without any viable proposal for a scheme of arrangement, whether by way of a deferred payment plan or by compromise. This section also allows existing managements to continue in management without adequate protection for creditors against dissipation of assets and inappropriate application of cash resources. However, Section 176 has a main problem. Now that the Companies Act 2016's rescue mechanisms have been understood, in the Companies Act of 1965, the Act provided little, as mentioned before, it has provided little to no detail regarding a rescue mechanism. The only form of rescue mechanism which was offered were either receivership, which enforces a debuncher trust deed in an event of default by a company, which pretty much doesn't actually rehabilitate a company, winding up, or engaging in a scheme of arrangement with the creditors. This had later created a void in terms of how a company could be saved or revived when it was insolvent. However, the Companies Act of 2016 came into force and with the objective of specifically helping financially distressed companies. The main problem arising out of Section 176 is the fact that there was a huge lack of existing provisions in order to facilitate the rehabilitation of companies. Or in other words, the Companies Act 2016 had changed from a termination culture to a rescue culture, meaning that companies do not necessarily have to cease operations or shutting down. This goes on to show that the Companies Act of 1965 was more of a termination culture, meaning that it did not actually provide methods in which an insolvent company could be rehabilitated. Therefore, the Companies Act of 1965 had failed to rehabilitate companies which were indeed insolvent. Now that receivership is understood that it does not actually rehabilitate a company, the scheme of arrangement also does not. Under Section 176 of the 1965 Act, the provisions in Section 176 are not confined to a debt of restructuring of companies in a financial distress, but generally speaking, they are available in order to adjust the rights of members and creditors, to reorganize the share of capital of a company, or perform a reconstruction or merger in the case of group of companies. A debt restructuring scheme under Section 176 generally involves a compromise proposed between a company and its creditors or any class of them. The CA 2016 had improved in a way to prevent the abuse of moratorium provisions by limiting the maximum duration for a restraining order to 3 months without extensions of up to a further 6 months, and only allowing the court to appoint an approved liquidator in order to assess the viability of the scheme of arrangement proposed and to prepare a report for the submission of the meeting of creditors and members. Therefore, in conclusion, it could be said that the Companies Act of 1965 pretty much offered no rescue mechanisms. As mentioned previously, the 1965 Act was in fact a termination culture. However, that changed when the 2016 Companies Act was enacted and enforced, which turned into a rescue culture. That is when the rescue mechanisms were actually adopted and applied.